Aloha and good morning, everybody. Today is Friday, August 9th. It's about 9:33, and I'm going to call this hearing and meeting to order. And we'll begin by taking statements from the public. Is there anybody in the
I'm
public?
sorry, Chair. We
Yep.
got to announce everyone who's present. So why don't we start with each member
Oh, okay.
stating their name for the record?
Sounds good. I need to stick that in there. Put that in the agenda. So I'm the chair, Kathy Lewis, and starting on the left, Stacy.
Board Member Stacy Aguiar, present.
Board Member Rachel Abel, present.
Board Member Scott Martin, present.
And on Zoom,
Board Member Lisa McNamara, present.
thank you.
And present as staff, Deputy Corporation Counsel Sylvia Wan, which is myself. Also present is April Supernaut, staff for the board, as well as Ashley DeVera, Board Secretary.
Thank you. Okay, at this point, I'm sorry, now we'll take statements from the public. Do we have people that have indicated they want to testify before we begin on anything pertinent to our?
Deputy Corporation Counsel Sylvia Wan, my understanding is that the staff have a few people registered in Zoom. However, they have not indicated which agenda item they would like to testify on, or whether they would like to testify at the top of the meeting or before the agenda item. So at this point, I'm going to turn it over to April in order to identify the signed up testifiers, so we may address them in turn.
Hi there. I'm going to start online. I see a Karen Doplinar. Are you all providing testimony? I'm sorry, you'll have to unmute. And if you are providing testimony, which case are you providing testimony on, please? Okay, move on. Is there anyone here present who is here to provide public testimony? Okay, seeing none, I'll turn it over.
At this point, then I would ask if the persons who are present but not testifying, if you can, please turn off your video feed. And then I'll turn the meeting back to the chair.
Okay. All right, well, we'll begin now with the new business. As indicated on our most recent agenda, the Bolton cases have withdrawn their petitions. So we're moving quickly then on to what is listed as the fourth matter, Matthew Coupe, which is PL-BOA-2024-000099. And so at that point, I will.
Do you want to read the rest of
Okay. This is an appeal from, excuse me. Appeal of the decision of the planning director dated January 31st, 2024 regarding approval of a variance PL-SVAR-2023-000041. The location 81-1040 Pu'ulehua Drive, Kealakekua, Hawaii. TMK paren 3 8-1-002:071. So I will now take opening statements. You have a maximum of 10 minutes for an opening statement.
Chair, would you like to
Appellant?
call the parties to the tables?
Oh, yes, okay. Go ahead and take your places at the tables. Make sure your mic works and everything. I'm going to give that advisement that you have here, okay?
So. Chair, I just want to bring to the attention, my understanding is that one of our members is going to recuse from this matter, Stacy Aguiar. Is that correct?
That is correct. I'll be recusing and I'll, from this case, item number 4, and I will be stepping out and you can call me when case 5 comes up. Thank
Okay.
you.
Okay. Jesus, I got to remember to do that. So, oh yeah, call it Stacy, okay. Oh, okay, have you established that your mics work? And if so, you can introduce yourselves. Parties. You go ahead, Mr. Coupe. Go ahead.
Matt Coupe, appellant.
Good morning, Deputy Corporation Campbell. Deputy Corporation Counsel Jean Campbell.
Aloha, good morning. Zendo Kern, Planning Director.
Okay, so let's proceed with the hearing. Oh, okay. Who's the secretary?
That's Ashley.
Madam Secretary, have you noted whether appellant has provided notice of the hearing to the surrounding property owners and proof of service was filed? Usually we just have a motion. We've never done that before. It's the first time. That's why there's crap.
Here,
Okay.
but I don't know if they did one for the actual.
Mr. Coupe, did you file a notice in accordance with 811 as far as the surrounding property owners?
Right, 500 feet,
Okay, for this hearing though, did you,
August 9th.
August 9th?
Right.
Okay, did you provide that proof of service to the board?
Right, I submitted it through the Epic system and
Okay, can we just have just a moment? Because we're going to see if we can confirm that. We need to make sure that that was done before the hearing can progress. You don't happen to have a copy of that with you today, do you?
of course not.
Okay.
Aloha, Madam Chair. I have on the record proof of service. Certified mail.
Thank you. Okay. Excuse me, I'm a little hoarse today. All right. I'd just like to remind both sides that we have read the record in this case. And with that in mind, do not repeat what you've already provided unnecessarily. And if either side begins to present testimony or evidence that's not relevant to our hearing today, you may be interrupted and stopped. There's one legal issue before the board, whether the director's decision in question should be reversed or affirmed. And with that, we'll begin. And we'll take your opening, Mr. Coupé, if you have an opening statement.
Well, I didn't know how to do this, but I
Okay.
prepared a response to their August 2nd,
A response to what?
memorandum of support document.
Okay. The opening statement usually sort of summarizes your position. It's sort of a short summary of your position and maybe a quick outline of your points. Do you want to try to do that off the top of your head? All right, go right ahead.
To start off, the biggest issue we have is the flooding issue that's posed by
Speak into your
this
microphone.
subdivision.
Speak into your microphone. Thank you.
Oh, sorry. Is this
That's
better?
okay.
It's the flooding issue that we have the biggest concerns about. And the statement or the approval that was given in January 31st of this year shows that the access for the subdivision was through an easement named AU1. And that easement roadway access goes across the known water course, and it is been altered, backfilled and graded without any federal or county approvals. And that issue is pertinent to this whole variance approval because the property owners or the future lot owners will be traversing over a known water course with no approvals. And when the ditch or the water course runs, they will be trapped, or they won't be able to gain access to their property because the water will be flowing right through this water course and preventing them from accessing their lots. That is the biggest concern that we have is the violation of the flood maintenance of that area. The second issue, which was the sign posting, was pertinent in the sense that the original posting of the sign was within a private gated community where the general public had no ability to view the notification of the sign and what was going on with this parcel. Subsequently, the director said that they didn't have any means for informing the subdivider to post the sign near the public roadway. We contend that the lack of posting of the sign on the public roadway violates other property owners and the general public's due process right to comment on this application.
Okay, thank you. And does the director have opening statement?
Good morning, everyone. Deputy Corporation Counsel Jean Campbell on behalf of the Planning Department. The Planning Director issued a variance for roadway improvement standards, including the construction of the roadway and the installation of improvements such as streetlights, as well as relief from water system requirements. So essentially allowing this property to install a water catchment system. The challenge that the appellant has made is to the posting of the sign and whether or not that complied with law and whether or not the director's decision to issue this variance without previously insisting on or requiring flood studies to determine whether or not flooding was an issue at this property is entirely inappropriate and an invalid basis to overturn this variance. The sign posting complied with law as far as the law requires posting in these situations. As noted in my memo, the factual situation for this property is that there is no public area that this property can post a sign. And in fact, the law only requires posting along a public street if one abuts the property at issue. No public street abuts the property at issue, and the planning department does not have any way or any authority to require a property owner to, one, post a sign on a public street that wouldn't be permitted, or to post a sign on property that the property owner, the applicant, doesn't in fact own. So the director's decision to allow posting where it was posted for this property along private Pu'ulehua Drive is completely reasonable. It's consistent with the way that the planning department has handled private property or private street sign posting in other cases. And it's also consistent with the intent of the code, because the code requires that if a property, for instance, is abutted by two public streets, one should post your sign on the busier, as to be visible from the busier of the two public streets. This was posted along the road that would be affected by the variance and the busier of the two possible accesses to the property. So the sign posting was entirely valid. With regard to the flood issue, there's a couple of things that are going on here. One, the variance, nothing in the variance would affect the flooding of the property. This property owner cannot be held responsible for grading, grubbing, road construction that may have happened off of their property in the past and that may have been done by someone else. And so the variance doesn't actually address any of those issues. Should the variance be denied, they would have to arguably put in streetlights, and that doesn't address flooding. The standard to which Pu'ulehua Drive would be required to be improved is a lower standard than it is today. So an agricultural road would be a gravel road, and currently Pu'ulehua Drive is a paved road. So effectively, it's kind of neither here nor there whether they do that. And really the proper venue to address flooding is when a property owner, whether they're improving a street within their own property, whether they're improving an access to their property, whether they're developing their own property, that's addressed at the Department of Public Works when you come in for your grading and grubbing permit or your building permits. And what we do with flooding is we don't say there's a flood zone in your area, you're prohibited from doing anything with your property. They sit down with some intelligent engineers and they figure out mitigation, which is precisely what both Mr. Coupe and his next door neighbor, who are affected by the same flood waterway, have done. They have lived on their property, I assume, for many years. The same flood zone runs through Mr. Coupe's driveway and through his next door neighbor's home and driveway. And obviously, they live there. Their house doesn't wash away. Presumably, their driveway doesn't wash away. They've done the adequate engineering that is required to develop within a flood zone. In this case, the flood zone does run through the portion, a large portion, it runs directly Malcolm Mackay through the lot at issue that's being proposed for subdivision. The variance wouldn't affect that area. The variance does affect a small portion of the flood zone that runs through the upper portion of Pu'ulehua Drive where it abuts this property. And so potentially, if a flood were to come through, that one lot, and if flooding completely cuts off all access, that it cuts off all access to all other 50 lots that are above this property because of flooding on Pu'ulehua Drive, and potentially one lot within the subdivision. Again, that's a DPW issue, and that doesn't have anything to do with the variance that is at issue here. So in short, I would summarize by saying the director's decision to issue this variance was in no way arbitrary or capricious. It doesn't violate the law, and it wasn't erroneous. So I would ask that this board please uphold the variance that was issued by the department. Thank you.
All right, thank you, Ms. Campbell. Okay, we'll start with the presentation of evidence and testimony then. And just remember, we try to limit this to about an hour for the whole thing. And we'll start with you, Mr. Coupe, if you have any testimony or evidence of any kind this is when the time, and if you're planning on testifying, we'll swear you in as well.
Okay. Is this where I can
It-
submit the response?
Yeah,
Um,
it's rather difficult when you're representing yourself, but we'll work with you and try to get you along with that. Would you take a seat over there if you want to be a witness and testify? And we'll have you sworn in, and then if you have exhibits you want to present to us, we can accept those into evidence as you go.
No, so I'm just going to note for the record, Madam Chair, I believe the appellant is stating that he wrote a response to the appellee's legal brief. That was otherwise due on August 2nd. So he's asking if the board would be willing to accept his written response now.
Well, we're more interested in hearing testimony and taking evidence at this point. I mean, we can take it. It's late. We don't have time to consider it right now, but you can use it as a guide for yourself as you move through your position of your statement. Do we need to have him move over there? Is there a reason why he should be at that table to testify?
No, I'm
Okay.
sorry, Deputy Corporation Counsel Sylvia Wan. So at this point, sorry, that was my timer for the opening statements. At this point, Mr. Coupe could just stay there. It looks like he has all of his evidence and exhibits in front of him. However, I guess I would inquire, Mr. Coupe, do you have any witnesses that you are going to present today, or is it just
No.
yourself? Okay, so if it is yourself, you're going to be in the dual role of being the appellant as well as a witness. So at this time, I'm going to swear you in. Okay,
Okay.
so I'll administer an oath, and then once that oath is finished, then you can continue with your presentation of the case.
Okay.
So if you could, please raise your right hand. Do you affirm the testimony you're about to give in this hearing before the board is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You may now proceed.
Okay. The exhibits were already entered in, right? So that I've done.
Yes, but if you'd like, you can use them and demonstrate to us if you want, if there's some way you can,
Okay.
amplify them a little. The other thing is just be prepared. It's possible some members of the the board may ask you some questions.
Okay.
Okay.
Very good. Well, like I said in the opening statement, the concern that we have is that the director has overlooked the warnings that we have issued to him regarding the flooding of the backfilling of the water course. And for them to say that the water course has no bearing on this variance is false. When the director states that the applicant is going to access their lots, their subdivision, over the known water course through easement AU1, and that water course has been illegally backfilled with no approvals, how can the department say there's nothing here, we can't do anything about it? The applicant has complete access to their property. How does that happen? We've told them in my objection letter in November, we've notified them in my February appeal notification that there's a problem. And they continue to say that there's no flooding issue for this property at all, that they can access their property whatsoever because this is just a variance and that it'll be taken up at a later date. The problem is these easements are granted in favor of that parcel. Easement AU1 is granted to lot 2 in favor of lot 2. Easement 1A, which is Pu'ulehua Drive, is also granted in favor of lot 2. The problem is if they try to access that parcel from any direction, they have to cross the water course. My parcel, my neighbor to the south parcel, the ditch or the water course runs between our parcels. I have direct access from Hawaiʻi Belt Road to my property. None of my buildings and roads, driveways enter in to the federal floodway or the flood zones. My neighbor to the south, they have direct access to Mamaloa Highway, Hawaiʻi Belt Road, and they do not cross over water course number 1. And so building within flood zones, we understand that, we understand the process and what's involved. But to cross over or through a known water course, that's a FEMA regulated floodway, that to me is a major issue that needs to be addressed before this variance can be granted. And regardless of who did the work and who backfilled, the problem is this development is being given permission to continue to use a known violated water course. If we look at Exhibit D, which was the map that the applicant submitted, I have outlined the area of violation, and it clearly shows where the easement 1A, Pu'ulehua Drive, transitions into easement AU1. And with the photos of Exhibit E, it clearly shows what's occurred in that area, and that this is not the 20-foot wide paved access road with a 30-foot easement that is made reference to in.
I'm sorry, Mr. Coupe, I'm getting really confused by your presentation. You keep using the word easement.
Yes.
I understand your application is asking about, or rather, appealing the variance that was granted. Are you talking about the variances that were granted or easements?
The variance that they make, that the variance application that was submitted makes reference to the access to those parcels, to those 5 lots that they've created. They cite easement 1A, which is Pu'ulehua Drive, that's a 100-foot wide easement. They also cite easement AU1, which is the easement on the east and south boundaries of this parcel. Easement AU1 ties in and connects to Pu'ulehua Drive or easement 1A. And so that's what we're saying is they're accessing their properties from the south side through easement AU1, because that's the side of the properties that don't have extensive flood zone inundation. Makes complete sense. If they try to come in from the north side or off of Pu'ulehua Drive directly, right now they're doing it with 1 lot. And that's on the furthest Mackay parcel. And all the other parcels would be affected directly from the flood zones and would have to require DPW and FEMA permission to cross over the ditch, the water course, to get to the non-regulatory areas of the flood zone or outside of the flood zone. So did that clear anything up?
As best as you could.
I have to address the one statement that the Corporation Council made here regarding that there's only 1 parcel that's affected out of the 5. And that's clearly not true. When you look at the map, that clearly the water course affects the easement access of AU1, as well as every parcel that runs Mackay from the top down. And it's not just the one northern parcel that's being affected here. Let's see, as for, let's see. The director stated that they had submitted an exhibit B showing the map of the FEMA flood zone map. And when you look at it and you look at the definition and the legend, it's a it's a regulated floodway. And being a regulated floodway, the definition means the channel of a river or other water course and the adjacent land areas that must be reserved in order to discharge the base flood without cumulatively increasing the water surface elevations more than a designated height. Communities must regulate development in these floodways to ensure that there are no increase in upstream flood elevations. When you see what the definition that FEMA defines a regulated floodway to be, and you look at the map that county has provided, clearly there needs to be some kind of stop, pause. Let's look at what's happened here and address the concerns of this floodway. And without proper engineering and proper oversight by the people that know how to handle these situations, we're going to create a dangerous situation, not only for us that live below the property, but also for the people that purchase these lots without knowing what they're buying. Because the county is actually telling you right now, there's not a problem. The problem will be addressed when the lot owner goes in and gets a grading permit or a building permit. That's all after the fact. What happens in the meantime? What happens when they're driving across that road? When the developer or the subdivider starts selling lots and takes people up there, is he going to point out to the lot buyer, oh, I have to make you aware, this area here was illegally filled in, and this is a major water course, and it does flood from time to time. I just want to let you know about that. So you may not be able to access your property from time to time. I don't see that happening. I think most common sense people can realize that that's not going to happen. And as long as the county sits here today and says, you know, we're not going to look at it, we're not going to address it, it's not part of the variance, we can let the subdivision be approved. You know, I believe the county's liable for any recourse that those lot owners may have, because our deed says we have access across easement AU1. Who said there's a problem with AU1? Only until they get into it and find out, wow, my road disappeared. I have no access. So to access the property across a known water course and a FEMA regulated floodway is, to me, a giant leap for a single lot owner. Maybe for a large scale developer, it's no big deal. They can write it off. They can engineer it into their pro forma, but from an individual lot owner standpoint, I myself have gone through the experience. I know what's involved. I know what the engineers tell me. It's not something I wanted to entertain. I have no structures that I have to traverse across the water course on my property to get to because of that reason. So when this came up, that's why I was concerned, because we've had years and years of experience with this floodway flooding and different volumes of water coming through there. And this is not a little stream. This is a major water course. The state DOT just completed repairs to that 48-inch culvert that goes across Mamaloa Highway because of the flooding that occurred in 2023. So this is not a water course to be taken lightly. And for the county planning department to say, oh, no problem, we can't violate the subdivider's ability to make a profit here and turn this into a subdivision. That's ridiculous. We're dealing with people's lives. We're dealing with the community. We're dealing with property owners like myself that live below the property. If this thing isn't engineered well, the rest of the community that lives below this project, we will bear the burden of the improper engineering. With respect to the sign posting, it's, I guess when the director makes a statement that they had no authority, they can't tell the applicant where to post the sign, they can't tell them to post it on somebody else's property for fear of public confusion and whatnot. I find it interesting that in their exhibit A, that they allowed or didn't admonish the subdivider from relocating the sign to the entry gate to the private community up there, and applauded that move. And so my question here is, if the planning department, the director says that that's okay, that you can go ahead and relocate that sign, we're not going to punish you for it, why couldn't the director say to the subdivider, oh, we have a problem. We have admitted in these documents that there's a flaw with 23 with 2317 in section C2, paragraph C2. And to avoid the whole problem of not notifying the public at large. The whole purpose, I thought, of this sign posting was to notify the public that didn't live nearby and wasn't notified because they lived 300 feet from the applicant, that this sign posting and notification was to let the public know, hey, we got something going on up here. If you're interested, come take a look. And if you'd like to, comment on it. Which is what I did, because I was notified in writing by the applicant because I'm 300 feet away. Well, what about the general public? County says, hey, the 50 lot owners suffice as public notification. We posted it on the most heavily used roadway, which is Pu'ulehu'a Drive. That's fine. Is it? We're notifying the people that live within the same community? Shouldn't the general public also have a seat at the table here and be able to comment? At least have the awareness made that there's something going on, whether they choose to come here and testify or write written testimony, that's up to them. But to take that right away from them, to have that knowledge, to have that notification, There's something wrong. And to continue to allow this to go on year after, the county even states in their own memorandum that this has happened before. Numerous parcels up there apparently have been subdivided or granted approvals that we don't know about because we're not 300 feet away. I'm not notified. A lot of other people haven't been notified. And if there's a sign that was posted, that would give at least the opportunity for us to know that something's going on and maybe we should look into it. Whether we act on it or not, that's up to us. But without proper notification, we're blind. We don't know what's going on. It wasn't until the county told me in their memorandum that other parcels up there have had approvals or applications approved. We didn't know because there's no sign posting. So in conclusion, to me, the sign posting, as small as people may make it out to be, it's a huge issue for the public. And violating, people's due process right to know what's going on, to have the ability to comment is critical in an open society. And that's what we need here. Transparency. Okay,
Thank you, Mr. Coupe. You will have an opportunity for a short closing when they're, and you can also cross-examine them as they are now going to be permitted to cross-examine you. And so we'll go ahead and commence with that. Thank you.
Thank you again, Deputy Corporation Counsel Jean Campbell. And I only have 4 questions for Mr. Coupe, so thank you. Mr. Coupe, reminding you that the matter at issue today is not the subdivision approval, but only the issuance of the variance. Is it your understanding that the flooding issue applies within the parcels as well as the roadway? And does the, let me restate that. Does the variance, the issuance of the variance, address the flooding issues within the parcels? The area, the area contained within the parcels.
does the variance address it?
Yes.
Not to the level that it should.
Value judgments aside, does the actual issuance of the variance affect what happens to mitigate or fail to mitigate the flooding issues within the parcels themselves?
You can't get, what we're saying is the flood mitigation issues within the parcels can be addressed by DPW. However, getting to that point requires the address of the access to this parcel.
Okay.
You're
Thank
talking
you.
about a variance and not the subdivision approval. The only chance I had to comment was on the variance that was, notified to me.
Okay, understood. Thank you. Does the issuance of the variance direct where these potential lot owners get access from their property?
Yes, under the approval of January 31st, the director states accesses from Pu'ulehua Drive over easement AU1.
But so the variance relieves the property owner from constructing particular roadway improvements and water system improvements. Does the issuance of that variance that allows them to not build those certain things and not connect to a county water system, does that variance itself actually direct them where they need to take access to their property?
Not directly.
Okay, thank you. In the issuance of the variance process, did the Department of Public Works have an opportunity to comment on this?
I believe they did.
And what was their input?
Well, I believe they were instructed strictly for the roadway access.
Thank you. Those are my only questions.
Okay, do any members of the board have questions?
Mr. Coupe, at this time, as the appellant, you would otherwise have the right to redirect. However, because you would be redirecting yourself, you can have a couple of minutes if you want to make a statement to address the questions that Ms. Campbell had just posed to you.
Okay. 1 second.
And as you're getting your thoughts together, I just want to remind you, the frame is just responding to the questions she just provided to you.
Correct. I have the January 10th, 2024 memorandum from DPW to the planning department regarding the subdivision variance. States, we have reviewed the subject application received on October 11th and have the following comment. We believe the minimum road improvement requirements codified within chapter 23 of the Hawaiʻi County Code provide public welfare and safety. However, should the planning director determine that section 2315 is applicable, we defer to the director's authority. So where in this review process does the planning department, because I haven't seen any statement from the planning department to DPW requesting any concerns regarding the floodways or the flood zones? We're talking about a major water course here, water course number 1. It's got quite a history. Nobody thought to look into it. I don't see anything here from DPW saying that there was a flood issue that requested that they needed to look into. I'm pretty sure if they were instructed to do so, or if they had the foresight to do it, they would have looked into it. They did it. What were they looking into? The road, the existing road design definition for Hu'ulehua Drive. Did anybody go out there and do a site review to confirm what was there?
Mr. Coupe, I'm just going to tell you, if you want to ask them questions, you can do that when they have a witness on the stand. That's the time for that.
Sorry.
Okay,
That's all.
okay. Like I said, you'll still have a chance to close after that. Do any of the board members have questions for Mr. Coupe? Okay, so we'll go ahead then and you may start your case.
Thank you, Deputy Corporation Counsel Jean Campbell again. I would like to call Director Kern as our witness. Go ahead and go over there.
Hi, can you state your name into the mic?
Testing. Zendo Kern, Planning Director.
Thank you. Can you please raise your right hand? Do you affirm that the testimony you're about to give in this hearing is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay, thank you, Board. Keeping in mind again that this at issue today is not the full subdivision approval. It is simply the variance. I only have 2 questions for the director, so we're going to try and keep this sort of simple. So Director Kern, was the sign posting as it was done consistent with the code and the practice of the planning department in situations like this where there is no public road abutting the property?
Thank you for the question. Yes, the sign posting as the applicant did is consistent with our practice, our procedure, and what's laid out within the code. In these situations where the property doesn't abut the public road, it can obviously be challenging. So then we look at what the intent is. And the intent is to notify the people that are being directly impacted by that property and to limit any confusion on that. So an applicant posted on their private property in an area that's going to have the most travel, that's consistent with the code. If they can get it on the public roadway, that's absolutely where it should go. But in other cases, it can't. If the sign were to be posted on a public roadway, first off, the county won't allow that within a right of way. We'd have to get special permission from the county to do so, which would come up to a whole nother myriad of different challenges. If the sign are to be posted on a private property, not on the applicant's property in a different area, the confusion that would come up from that would be paramount. And so the applicant did post the sign in accordance with our code as in past practice, and we've had no issue with that. Thank you.
Okay, and I guess, apologies, I'm going to retract my 2 question, ask you one more question. The duration of the sign posting, as I understand it, and this can probably be a yes, no, the duration of the sign posting is required to be from the moment of the application through the issuance of the decision.
Yes.
Okay, so posting of the sign, as soon as you issued that variance approval, leaving the sign there and relocating it is a courtesy.
Yeah. In another way, I almost had thought about a section of the code that would ask applicants to take the sign down, because we've had signs in certain properties that have been up there for years that I don't think need to be there anymore. So once a variance is approved or the application is approved, the sign can come down.
Great, thank you so much. Okay, and then so moving on to flooding, how is flooding typically addressed?
Flooding is a Chapter 27, Hawaii County Code Chapter 27 matter. The planning department deals with Chapter 23 subdivisions and Chapter 25 zoning. And so within the county, we work together as a team. We look at land use, we look at planning. Fire department's going to look at fire, police are going to look at police matters. Department of Public Works administers Chapter 27. They're the engineers. They're the ones that look at flooding. They're the ones that handle flooding. And so when we receive an application for a variance, we send it out to review to various agencies. And in this case, Department of Public Works, police, et cetera. And so what we do is we rely on Department of Public Works, giving us their recommendation, giving us their opinion based on them being experts, them being engineers. In the planning department, we're not engineers, we're planners. And so we take their information and then we will basically adjust the variance or adjust the subdivision application to comply with what they're asking for. In this case, on their memo, they did not have any issues with the flooding, and it was very clear what they said, so we did not have to go any further on that. And then also we looked at it from kind of a common sense point of view too. This is an existing road there with many people traveling over it. And so the request to keep it as an as-is condition with no requirements from Department of Public Works and them not referencing anything that in this variance request, we move forward in the manner that we did.
Thank you. I don't have any further questions.
Thank you. Now, Mr. Coupe, it's your chance to ask questions of this witness.
Okay. Director Kern, you just stated that you limit your scope on this particular application with the existing roadway. Did you instruct DPW to look into any of the flooding concerns that were noted on the applicant's preliminary map?
So, working in a county in a team manner, we don't instruct other departments what to do. We rely on them based on their request and their information coming back to us.
And so you didn't instruct DPW to look into this. They didn't, obviously must have missed the flood zone issue here. Now that you are aware, or now that you were made aware of this potential issue of the illegal backfilling and grading of that easement, how come you haven't done anything to notify the property owner, Kona Hills, of that action?
So when we receive, in this case, information such as this, or a complaint in this case, that would be directed to the Department of Public Works. So what you're trying to address here is a public works matter. It's not a planning department matter. And so we receive at the planning departments calls, complaints. There's a flooding issue. Somebody did grading and grubbing. I don't believe they had a permit. You know, the myriad of different things occur. And we then simply say that we are sorry, we do not administer Chapter 27. That's a Department of Public Works issue. So what you're bringing up should be addressed with the Department of Public Works, because as it's their jurisdiction. You're asking me to address something that's outside of my jurisdiction. And if I believe I did that, I would probably be liable for an appeal.
The variance approval that you issued on January 31st specifically calls out multiple times the access to those lots over Pu'ulehua Drive and easement AU1. Is that not true?
I believe that that is true.
So you knew when you issued that letter of approval on January 31st that people were going to be traversing over, through, and across a known water course. Is that not true?
You're asking me to answer something that's outside of my jurisdiction.
No. The easement is clearly stated on the preliminary map here by the applicant. It is clearly defined on this map. I can see it, the board can see it, where easement 1A is. Pu'ulehua Drive ties into easement AU1.
The application, which was full of all the facts, was processed, reviewed, looked at the Department of Public Works, and processed in accordance with our code. I don't know what else to say to you.
So you're saying that there was a complete malfunction on the part of DPW, that they didn't catch this? They
I'm
didn't
not
inform
saying
you?
I'm not saying that.
How did this happen?
Again, we're processing a variance as an as-is condition based on what was represented. We process this in accordance with our process, going out for input from the various agencies and relying on their information from an engineering standpoint to give us that information if it's needed.
So nobody in your department, under your direction, questioned DPW as to whether this was permissible or not to cross over this water course, this FEMA regulated floodway? Did anybody go out and verify with a site verification that?
Just ask one question at a time,
Sorry.
please.
Did anybody from your department go out there and verify in the field what they were looking at approving here?
I would have to double check on that. Again, people in my department are not engineers. We're planners. We process an application and we rely on the department that is their code to administer to go through and do that. And again, what you're asking me to do is administer a section of code that's not mine.
So you're processing this application with complete blinders on as to what this map is showing you. That's what you're telling us?
I'm not going to say that I'm processing an application with blinders on. No.
Mr. Coupe, you're getting into the realm of argument now. So let's save argument for your conclusion. If you have a question, you want to bring out a fact.
Okay. At no time did you ever instruct DPW to go out and inspect this easement, AU1?
It is not my job to instruct Department of Public Works what to do. We send them the application as complete for their review and their recommendation.
Okay. With respect to your sign posting statement, do you concur that the real purpose of that posting is notification to the public?
The posting of the sign is to give notification to the public and the folks that would be impacted by it.
Right. And so do you view the folks, the general public that live below this development, this private gated community, as people that should be informed of projects that are taking place above them?
I would say that that would be subjective in this case. The sign code is what it is. The person places it on their property in a manner that is seen in the most traveled way. And I don't know how to have a person post it on a property that isn't theirs or in a public right of way.
But you stated in your memorandum that it was okay for the applicant to repost that sign along the fence, on the fence of the gate that enters into this private gated community, correct?
I believe that was done in abundance of caution just to open up more. I mean, we're always trying to be more public and more open and more transparent. But in this case, with the sign posting being on the person's property as it was done, that's the best that they can do.
So you didn't instruct them to do that. They did it on their own.
Well, it didn't come from me.
They did it on their own.
I'd have to look into that. I'm not sure.
Okay. If it was okay and you didn't fine them or tell them to remove it once you knew about it, what would have been the harm then for them not to post it along the highway,
Yeah.
along Kona Hills property that abuts the county right of way?
Mr. Coupe, I believe this issue has been asked and answered in their case in chief. We've already,
No, he has not answered the question.
He-
If they posted the sign on the entry gate, which is 300 feet from Mamalahoa Highway, Hawaii Belt Road, why couldn't the applicant have posted it along the highway?
you're just getting outside the variance and, I mean, I'll let you ask this question, but then let's put that issue, unless you have a new fact you want to bring out. Ask a simple question and let him answer the question.
Could the applicant have posted the sign along the property boundary of Kona Hills facing Mamalahoa Highway without repercussion?
The sign needs to be posted on the subject property during the course of the application.
No more questions.
No more questions? Okay, do you have redirect?
No redirect, thank you.
Okay. And now, does the board have any questions for the director? Okay, Rachel?
Are you aware of which department is responsible to reporting to FEMA if a noted water course is affected?
Yeah. Excuse me. So Department of Public Works, they're the ones who work with FEMA. They're the ones who work with flooding. Everything flooding generally leads towards an engineer. The engineers are within Department of Public Works. So when we're working on matters with FEMA, Army Corps, all of that, it's always with Department of Public Works. We may be a partner with it in the conversation, but it's their jurisdiction.
In this particular matter, were you a part of that conversation with the Department of Public Works or FEMA?
In this case, we sent the application for review for them and look for their memo coming back to us on what their recommendation is.
Okay, so no response from FEMA?
No response from FEMA to my understanding, no.
Okay, thank you.
Thank you.
Okay. So then I guess at this point, we'll have some short closing arguments. Just a summary of the overall picture here. It'll take no more than about 10 minutes. And you can begin, Mr. Coupe, when you're ready.
Yeah, I guess in summarizing our position, it's the concern we have is the directors kicking the can to the next department saying, it's not us, this isn't the right venue. How do we address the concerns? You know, we're just a property owner. And we see an issue that really does affect not only us and the property owners below us, but the subdivided lot owners that are gonna be the ones most impacted when that water course runs. And for planning to sit back and look at this, I'm not a planner. I don't work for the planning department. I'm not an engineer. But as a property owner, I can look at this map, I can read what's on it and clearly know, oops, there's a problem here. My own personal experience in trying to lay out and design and build a home on my own property, I went through this process. I know what's involved. I know what the costs are associated with dealing with working within a flood zone. The fact that we point out with photos, definitions from FEMA, from their own department, chapter 27, that they have a problem here that needs to be addressed properly. And to sit back and say, it's not my department, we don't handle it, it's their problem, that's unacceptable. Like I said, you're dealing with people's property, investment, and their lives. And to take the attitude that this is not a big deal and that it can be dealt with down the road is false. The people need to be held accountable to do the right thing, to have the right engineering done so that everybody can be confident that when they buy this lot, that they have the rights that they were duly granted in that sale of that lot. Then they can deal with their own issues within that lot with respect to the flood zones and everything else. Also, just to summarize the signposting, the attitude that we don't have a law that tells us to post it on the highway. We can't do it within the county right away because that would require great feats of heroism to get that accomplished. The simple question, what's it worth to violate the notification process to other property owners that might have a real legitimate concern on what's going, not just with this parcel, but any other parcel on this, what is this thing? 10,000 acres up there, 11,000 acres? And the rest of us down below don't have a say in what kind of development is going on up there? Just because chapter 2317 doesn't say specifically you can post a sign down there? If the county has known about this for years, they've been violating everybody's due process right for years. We should have known for years what's been going on. And to hide behind 2317 to say, oh no, we can't do anything about that. No, they do, and they should be compelled.
Okay, thank you, Mr. Coupe. And Ms. Campbell?
Good morning one more time. I'd like to remind the board of several things. The first being the scope of what is at issue today. We're not talking about the entire subdivision approval. We're talking about the issuance of a variance that allowed relief to this property owner from particular portions of the subdivision code, which in this case would have required them to build Pu'ulehua Drive out to non-dedicable ag standards, which again would have been gravel. It's currently paved. And the installation of streetlights, which are not there today, but the variance allowed that this particular owner in going through the subdivision process would not need to install streetlights. And it also allowed them to use water catchment systems. The county as a whole, the government generally, can only do what the law allows us to do. So while it may be very frustrating for the public and for those of us who work within the county that we can't do all the things, each department of the county can do what it's authorized to do. And we very carefully put experts in different areas into different departments within the county because planners know how to plan, engineers know how to engineer, fire department knows how to put out fires. We have each of these groups working together through a process that's been established. And the county government, governments as a whole, get in a lot of trouble when we step outside our authority. And those are the appeals that should be in front of you. When a director, anybody in the government, abuses their discretion and goes too far and does things that they're not supposed to do and things that they're not authorized to do. I'd allow that the signposting as well is one of several layers of public notice that take place when a variance is requested. There's a signposting on the property, which is a very standard practice. We've talked a lot about it today. There's also a mailing that goes out to owners within 300 feet. And then before the director makes a decision, the county publishes a legal notice in the newspaper. The planning department alone spends about $40,000 a year in publishing legal notices. So whether or not this one sign told the entire public about this variance is only one of several layers of process that takes place to make sure that people know what's going on. And the planning director doesn't have the authority to do the Department of Public Works director's job. If he steps outside of his authority, that's where we begin to get in trouble. And again, those are the appeals that should be in front of you when the director is doing things that he is not authorized to do. We rely on one another's expertise here, just like we rely on this board to have the expertise to help us make these decisions and make sure that we're doing it right. So I would ask this board to recognize that the director's decision was thoroughly within his authority. It wasn't erroneous. It didn't violate the law. It wasn't outside his discretion. And alternatively, overturning it doesn't address any of the issues that Mr. Coupe is rightly concerned about. Flooding is a real issue, and that is a Department of Public Works issue. So overturning this variance would have no effect on that whatsoever. Thank you.
Okay, thank you very much. So at this point, I will entertain a motion from the board on this matter, and then we'll have discussion. Yeah, well, do you know?
Deputy Corporation Counsel Sylvia, I'm just going to note for the record that the hearing is officially closed. So at this point in time, this hearing is now just for the board to entertain motions on how they want to decide as far in regards to this appeal.
And well, you start with, the ultimate decision, and then we can discuss it and modify and amend as needed after discussion, but just something to get us kickstarted. It'd be great.
Deputy Corporation Counsel Sylvia Wan. Chair, at this point, it seems like the board members may need a little bit of time to put together a motion. So I would suggest if we go into a few-minute recess, just to allow them sufficient time. Maybe 5 minutes?
That's a great idea. We can take any little pit stops we need. So we'll take a 5-minute quick intermission and reconstitute at
10:53.
Thank you.
Well,
All right, we'll adjourn, what's the opposite of adjourning?
Reconvene.
Reconvene, thank you. And so at this point, I'm entertaining a motion from one of the board members.
Hi, I make a motion to affirm the planning director's decision in PL BOA 2024000099 dated August 8th, 2004. The decision was not clearly erroneous and the decision was not arbitrary or capricious, nor was it an abuse of discretion based on that fact. The appellant did not sufficiently prove his claim.
Anybody's?
I second.
Okay, now we'll have discussion on the matter.
I'm sorry, Chair.
Yes.
Okay, we need to wait for Lisa to
Oh,
return.
good point.
Now we have quorum. Now you can open discussion.
Lisa, I don't know if you heard, we have a motion to affirm and second, and we are now going to begin discussion.
Did hear that.
Thank you. Does anybody have any further discussion? I just want to add one note, just almost informational in a way that we as a board do not have jurisdiction to change statutes, add to them, or otherwise modify or do something to a statute that's not there. And so with that, I guess we will take a vote on the motion. And we'll do that individually. Would you roll call? Thank you.
Yes, absolutely. Thank you. Member Abel,
Aye.
Member Martin,
Aye.
Member McNamara,
Aye.
and Chair Lewis.
Aye.
You have 4 ayes, motion passes.
Okay. Matter is concluded. Thank you very much, Mr. Coupe, for your time. We appreciate your presentation and the time it took you to come. We really do. And good luck in the future. All right, then moving on to
Chair,
the next.
Excuse me,
oh,
Chair.
Chair, if I may. Typically, the department, the presiding or prevailing party is asked to draft a decision in order for the board's consideration. Would you like the department and I to do
Yes,
that?
we would. Thank you very much.
And Chair, would you also like to have that present by the next meeting or 2 months, I guess it would be?
So we are not having a meeting in September due to a conference of planners for the whole state taking place at the time. And so our next meeting will be, I
Would be in
have it somewhere.
October.
Will be
I think it might,
October
11th. Okay,
in Kona or Hilo?
in Kona.
In Kona. At that point, Mr. Coupe, you should know that we as a board will entertain the prepared decision and decide whether to take it as written or add to it or anything of that matter. So you can be present to hear that if you like. You can also attend via Zoom if that's easier, but just so you know, that's the next step. And then once that's done, then the matter is closed unless it's appealed by you, then in which case it goes to the court.
Deputy Corporation Counsel Sylvia Wan, Chair, can we set out some deadlines for the parties? I believe, is it 2 weeks? 2 weeks prior to the next hearing, so 2 weeks prior to October 11th, which would be, do we know?
No.
2 weeks prior would be the deadline for the draft order. And if we could have a response a week later, if the appellant wants to issue a response to the draft order. And then at least that'll be enough time for the board to be able to see the draft order as provided by the prevailing party, which in this instance is the appellee, and any response or opposition by the appellant. And just know that at this time, it wouldn't be for further argument. It would just be for corrections for any errors that may or may not be present in the draft order.
okay. How do I submit it at the hearing or beforehand?
It would be beforehand, so it'd be a week before the October 11th date, and you can submit that through the Epic system.
Epic, okay.
So if I may, the dates, this is April Supernaut staff for the board. Date 2 weeks prior to the hearing will be September 27th. And then 1 week prior to the hearing will be October 4th for any rebuttal. Thank you. And this will be in the minutes when the minutes were shared out with all the parties.
So October 4th. Okay, for you. All right, thank you.
Thank you, Chair.
That is great. All right, I believe that we're ready to move on to the next new item, which is the motion to intervene. Here it is.
I'm sorry,
Oh,
Chair.
we need to call Stacy.
Yes,
in.
can we have another short recess just so we can get our fifth member back to the panel?
So we'll just recess for 2-3 minutes. Sure. I should just have a little one eye to the side before I say anything because I always get. But I'm realizing this script that I don't even know where we got it gets missing a lot of stuff. I believe we're ready to reconvene and,
It's 11:02. I'll just note for the record.
okay. And we now have present in our midst again, our missing board member, Stacy Aguilera. Thank you for returning. All right, we will commence with the C and J Coupe Family Limited Partnerships motion to intervene in PL BOA 2024-000104. We have given this matter its a separate number. This matter is numbered PLBOA 2024-000108. And I believe we have Mr. Yamamoto on, is that who that is? On Zoom?
Mr. Kupchak will be,
Say that again, please.
Mr. Kupchak will be addressing this matter.
Oh, he works with me.
And just to clarify, you're in representation of C&J Coupe Family Limited Partnership?
Yes, I am in item number 5. Mr. Murakami will be addressing item number 6. And I'd like the record to reflect that Charles Coupe is present virtually online on the camera for Karen Doppler.
Oh, okay.
He's the client representative.
Okay, thank you.
And then
What's his last name? What was your last name, please?
Mine is Kupchak, Kupchak.
Thank you. Oh, yes, and here for the planning department is,
I'm sorry, can you turn on your mic? There you go. Try again.
Deputy Corporation Counsel Britt Bailey.
thank you, Ms. Bailey, and we have also present the planning director himself. And is there anybody else appearing here in this matter? Yes.
Good morning, Chair Lewis, Derek Simon, on behalf of the appellant 1250 Oceanside LLC. On behalf of my client and myself, I'd like to thank you and your staff for your time today.
Okay. All right, then we can proceed with the, we'll start first with the argument of the filer of the motion. And who's going to be arguing?
Mr. Kupchak.
Okay, Mr. Kupchak, you may proceed.
Thank you, Madam Chair, board members. It's my understanding that there is no opposition to this motion. And that's not unusual in this case because the county, Oceanside, and C&J are all here participating pursuant to court order. C&J owns the property on the south side of Hokulea, Oceanside's development that's in question here, and it is specifically referenced in the development agreement and in the ordinances 96-7 and 8 that are subject matter of some of the proceedings. And on top of that, it is its petition that is being discussed in this particular item on the agenda. Therefore, we have a due process right to participate in any proceeding with respect to its petition. It's my understanding that today we're only examining the right to intervene and not the merits. So I ask you to grant the motion, please.
Okay. All right, Ms. Bailey, do you wish to voice any argument?
No, we'll just stand by our submission. We don't have any objection to the intervention.
Okay. Everybody familiar with that?
And then
Okay.
I guess the next would be Mr. Simon, who represents the appellant.
Okay, Mr. Simon, then your position on this?
Thank you, Chair. Yeah, we did file a position statement in which we generally did not oppose the request to intervene. So we'll stand on that unless the board has any questions.
Okay, thank you. Does the board have any questions of anybody? Okay. And I guess hearing that, I would entertain a motion. Whether to grant or deny the motion to intervene?
Chair Stacy Aguiar, I make a motion to grant the appellant's request to intervene in PLBOA 2024-000104
Okay.
item
And-
number.
Madam Chair, we are the petitioner, not the appellant. The appellant is Oceanside.
Apologies. So I'll correct my motion. I make a motion to grant the petitioner the right to intervene on the upcoming PLBOA 2024-000104.
Thank you.
Board Member Rachel Abel, I second the motion.
Thank you, Rachel. And all in favor, say, do you
Sorry,
think we need a roll
discussion.
call?
You need discussion
Oh, sure,
first.
of course. Sorry. I like to cut out that. Any discussion? Okay. And, no, yeah. Okay, do you think we should roll call?
Yes.
Okay, we'll roll call this one.
Thank you. Member Aguiar,
Yes.
member Abel,
Here.
Iron.
Your vote?
Oh, sorry. Aye. Thought you said roll.
I did. but
member Martin,
That's what they call.
Yes.
member McNamara,
Aye.
and Chair Lewis.
Aye.
You have 5 ayes, motion passes.
Okay, that was fairly painless. And we will move on then to the.
Chair,
oh,
before we
what
move
did I
on,
do?
nothing. You're fine. You're just trying to be judicious. I just want to make the new party who has just been intervening or intervening that matter PLB BOA 224-000104 is currently set for hearing on the October 11th date. The board will follow up with providing you access to that case so that you may file, as well as including you in any further scheduling of pre-hearing conferences. I believe there is one already scheduled. We will send you notification of that. Thank you.
Very good, good. Okay, now we will move on to the final.
Sorry,
item.
Madam
No,
Chair.
we won't.
This is April Serpernot from BOA staff. Does this require an order?
I believe it should require an order. I believe that this can just be an order coming from the chair, though.
Okay, very good. Thank you.
Sounds good. Okay. Moving on to item 6, and that is the similar motion to intervene, petition to intervene, I should say. The petition itself is PLBOA -2024-000109. It is a petition to intervene in the C&J Coupe Family Limited Partnership matter PL-BOA-2024-000105. I think we can dispense with introductions and so forth. All the same parties are assembled, represented by the same individuals. Is that correct? As in the last matter? Okay, if that's the case, then Mr. Kupchak, would you like to?
Mr. Murakami is addressing this matter.
Can you spell that name, please?
I can. It's Murakami, and I'm appearing on behalf of the C&J Coupe Family Limited Partnership.
Thank you, Mr. Murakami. Okay, you may proceed with any argument you have in favor of your petition.
Our petition sets forth our compliance with and our client's interest in this appeal. We do believe that we satisfy the rules of the board and along similar lines as the earlier petition that was just granted. We do have a stake and standing to appear and defend or represent our client's rights with regard to the pending appeal. We'd ask that this board grant the petition and allow the intervention. Thank you.
Thank you. Okay, does the corporate counsel have Ms. Bailey?
Again, we'll stand on our submission. We have no objection to the intervention.
Okay, thank you. And Mr. Simon, your position?
Thank you, Chair. Yeah, we will also stand on our filing. Thank you.
Okay. All right, then I would entertain a motion.
Chair, I make a motion to grant the intervener the right to intervene on the upcoming petition PLBOA 2024-000105.
Thank you.
A second.
Thank you. Discussion? Any discussion? Okay, hearing none then, April, call for
Yes.
the vote.
Member Aguiar,
Yes.
Member Martin,
Yes.
Member Abel,
Yes.
Member McNamara,
Aye.
and Chair Lewis.
Aye,
You have 5 ayes, motion passes.
thank you. Okay, that concludes
And-
that matter, and like the other one, you will have access to the file and any orders that have been issued or any other matters that have been filed, and you will also be party to any scheduling. And we,
Deputy Corporation Counsel Sylvia Wan, I'll just note that PL-BOA-224-000105 is presently scheduled for a contested hearing on October 11th, 2024. The new intervener, CJ Coop Family Limited, will now be a part of any further pre-hearing conferences. I actually do have the date for the next pre-hearing conference. This will actually apply to both cases. It is presently set for September 6th at 9 a.m. You will also be notified through BOE staff after this hearing with the
Thank
same dates.
Thank you.
May we ask if that is a virtual attendance or in person?
It's a virtual attendance. You will
Thank you.
also be provided a link to appear virtually.
Thank you.
Thank you.
yeah, okay, thank you. And that concludes today's meeting and hearing, and thank you all for your attendance and,
Well,
oh, no.
I mean, sorry, Chair. So that does include
Oh,
the
we have to
hearing
do
of
the
our
minutes.
cases,
Have to do the minutes.
but we do have a couple matters still on the agenda.
Yes. I'm sorry, I almost forgot. We have a minute, let's see, where's my, okay. So we have minutes that you've been provided with, board members, for our last meeting, the June 14th, 2024 Board of Appeal hearing minutes. And at this point, I would entertain a motion to approve or amend, whatever.
Board member Rachel Abel, make a second the motion. Oh. I make a motion to approve the minutes.
Thank you, Rachel.
A second.
All in favor, please signify by saying aye.
Discussion.
Oh, discussion.
No
Any
discussion.
discussion? Okay, all in favor, please signify by saying aye.
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 Aye. And all opposed, nay. Okay, hearing no opposition, that motion passes and the minutes have been approved. Now we're on to, are we going to do any kind of announcements from the staff or? We are. Who has an announcement? Yeah.
Well, as far as announcements from
Sometimes we
Corporation
don't do.
Counsel, I'll just note as far as the status of appeals of board appeal decisions, at this time, Corporation Counsel has nothing to report. Nothing has changed since the last hearing. And I'll turn it over to staff is whether there's anything outstanding petitions.
Aloha, Chair. All we have is about 10 cases currently on the October agenda. However, those pre-hearing conferences have not yet happened, so we will keep all of the board members apprised as those happen. Thank you.
Thank you, April. All right, now what?
You did this, you did. So now is there any other announcements and then you can adjourn.
Okay. Does anybody present have any announcements? Otherwise?
I will just note for the record that the September 13th hearing will not be happening as the Board of Appeals staff will not be available at that time. So that hearing will be canceled. The next hearing date that this board will be having will be on October 11th, 2024 at 9:30 in the morning, I believe, here in this same room. So
Same
that's,
back plate, same back.
yes.
All right. Okay, then
I make a motion to adjourn.
I second the motion.
all in favor?
Aye.
All opposed? Nay?